Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy podcast. Today, we are going to be talking about plea negotiations, talking to the DA, having a conversation with the DA about your client's case. I recently recorded a podcast with a district attorney in Buncombe County, Kat Parrish. That episode will actually air next week. So if you want to hear from the state, all you got to do is tune back in for episode 44, and you'll get to hear Kat talk to us about some of the tips and tricks from the other side of the aisle, so to speak. But the conversation that I had with her got me thinking about some of the things that you can do well to improve your chances of getting the desired outcome that you are hoping to receive on your case. Whether that is a felony, misdemeanor, DWI, whether it is a speeding ticket. When you go in to talk to the DA to negotiate, there are some rules of the road that can help improve your chances of getting the desired outcome that you are hoping for your client. So we're going to go over 5 simple tips for improving your conversation with the DA, your plea negotiation with the DA. So to kick it off, number 1, know where you are going. What do I mean by that? Know the desired end outcome. Now, this may seem simple, but the more certain you are about what it is that you are asking for, the better you will be prepared to present that as a logical, rational option, the better prepared you will be to achieve that desired outcome. I think so many times, and this is true of any negotiation, so many times we go into a negotiation with this idea that, well, let's let the other side make an offer first. And depending on your DA, that may be a good opportunity. It would be terrible if you go in and offer a improper equipment when the DA would have been inclined to dismiss the case. So certainly you don't want to jump the gun, but knowing where you ultimately want to end up will let you know if the offer from the DA is one that you should be inclined initially to accept or whether you should try to push a bit harder. So know where you want to end up. And obviously, we always want to end up at a dismissal on every case, right? We'd love if we just walked into the DA's office and they said, what's your client charged with? 3 DWIs? Sure, we can dismiss all of those. It seems like your guy has been a good human being, a good citizen. We'll just kick him and let him get back on the road, right? That would be the easy way out. That's not how it works, right? That's not the reality of the situation. But you need to know where you are hoping to end up. If you have a client that has a speeding ticket, a high speed, and the policy in your county would be to normally reduce that speed to 9 over or to an improper equipment, if you are hoping to get to a dismissal, you need to know that you're going to have to do some legwork to pull that out, right? You're going to have the client's driving history. You're going to have the client do a driving class, maybe some community service, whatever it might be, to legitimately ask for that speeding ticket to be dismissed. But you want to know where it is that you're ultimately going to end up. So never begin a negotiation with a DA on a case until you know where it is that you're hoping to go. Now, let's suppose you're fresh out of law school or you're handling a new kind of case for the first time and you need to go negotiate with the DA's office about that. What do you need to do? You need to talk to an experienced attorney, one of your colleagues, and say, what should I be hoping for on this particular case? What is it that I should be kind of asking for? what would be the expected outcome, what are the different ranges of things that you've seen on a ticket of this nature. Know where it is that the baseline is for the type of charge that you're handling, and then get used to understanding where there may be some wiggle room, where there's a way to kind of request a special outcome. So talk to other attorneys in the county that you're practicing in to see what they have seen on that particular type of charge and what methods that they have used to ask for a departure, a downward departure from what it is that the state would typically offer on that particular type of charge. So number one, know where you're going. Number two, set up a time to talk. I cannot overemphasize this. Set up a time to speak to the DA that is not in the courtroom the day that your client's case is supposed to be handled. In many counties that I practice in, on the day of court, there is a line of attorneys that are waiting to speak to the DA. 2, 3, 4, 5, 6 plus defense attorneys, whether that's private or public defenders, that are waiting to speak to the DA. The DA has a mammoth calendar. They are trying to go through each case. They don't have time to talk to you about the details of the case. Okay, that's speeding 75 and a 60. What if we reduce that to 9 over? You've got an intoxicated and disruptive. Let him do 5 hours of community service. You're not going to have the ability in that pressure cooked environment to calmly talk to the DA about your client. So the best thing that you can do in talking to the DA about the special circumstances of your client's case is to set up a time to let that conversation happen. It's almost never a good idea to ask a DA who is in a rush to help you on a ticket, unless they are just so stressed out that they'd rather just dismiss something than deal with it, which is going to be the rare exception. Then it is going to work to your client's disadvantage. It's going to work to your client's disadvantage to handle it in a pressure cooked situation. So don't do that. Think about in your own life times when you are engaged in something, doing something, and then another person comes and interrupts whatever it is that you're working on, or 3 people come and interrupt what you're working on. Are you devoting your full attention to that person? No, of course not, right? You're not devoting your full attention. You can't concentrate. You can't think about it. It's just not a good environment, a conducive environment to having a conversation. And when you are asking for special circumstances for your client, you need to be able to engage in a conversation. So don't plan on handling your client's ticket the day of court. The other issue that doing this creates is that you have multiple other attorneys that are in that line waiting to talk to the DA that are within earshot, and the DA is looking at them and saying, well, if I dismiss this guy's ticket who is going 70 and a 50, now I'm going to have to dismiss the next 3 people's speeding tickets as well. The next 3 attorneys that are going to talk to me, I'm going to have to dismiss their clients' tickets as well, because I've already set the bar at just dismissing a 20 over. There is a couple of counties in our area where you go into the back room of the courtroom, and there's a DA that's in the courtroom, and then there's the DA that speaks with the attorneys in the back room. So you have the one that's handling court and then the one that's speaking to the attorneys. And it's always made me uncomfortable. And again, this has been in multiple counties that I've seen this be the method of operation. It's always made me uncomfortable to negotiate with a DA about my client's case in front of other attorneys. Because in that environment, it makes the DA realize, Whatever I set as the bar in this particular person's case, now that is the new bar for everybody else that I have to talk to. And how willing would you be to do that? You cannot pass out dismissals like candy when everybody around is kind of watching that, right? Because now they know, hey, this is what I need to do to get a dismissal, is just come talk to this person. So I get the sense that most DAs that are put into that position and have to negotiate with multiple defense attorneys at the same time, they don't offer very friendly plea arrangements because they don't want to set the bar. And I don't blame them for doing that. So you have to be able to carve out time with the DA. Now make sure that you are doing your best to do this on the DA's watch, not on your own, right? If you're trying to get a good outcome, make sure that the time is going to be conducive to the district attorney's schedule that you're wanting to speak with. But give them the freedom to be able to individually assess your client's situation with the time that they need, with the conversation that they need, and without the outside influence of other people in the room that they need in order to have the freedom to get to the end result that you are looking at, to create special circumstances, special requirements to get to the end result that you are looking for. Carve that time out. Go into the courtroom on the day of your client's case ready to handle the case, not looking to negotiate. So number 2, set up a time to talk with the DA. Number 3, know your client's case. Here, I'm going to have to ask you to do as I say and not as I do, because this is something that I really need to step my own game up on. So this is advice that I have seen pay off and something that I don't often practice what I'm about to preach. And that is to know your client's case. You are the communicator to the DA about the case. They don't have any knowledge about the situation before you come talk to them. Maybe they can access an F1 screen. Maybe they can access a printout of the citation. Maybe they can even get some officer's notes here or there. But other than the piece of paper that is in front of them, the entire narrative of the situation is your responsibility. You have to know exactly what was going on at the time of the charge. Not every 9 over speeding ticket or 20 over speeding ticket or 30 over speeding ticket arose in the same location at the same time with your client going to the same end destination. Not every person that is charged with possession of cocaine. Not every person that is charged with driving while impaired, driving with a revoked license. Not many of these charges are going to have the same set of facts between one client and the next. And so from the DA's perspective, when they see a DWLR charge or a possession of cocaine charge, a speeding ticket, assault, it's all the same. It's all the same because they haven't had the time to be able to differentiate anything but what the charge is. It is a Class I felony. It is a Class II misdemeanor. It carries these consequences. That's what they're pulling in information-wise because they don't know about the specifics of the case. It is your responsibility to know the case and to be able to communicate the narrative of what happened in a compelling way for your client. If you don't know what happened, if you're not communicating what happened, then the narrative is not going to go well for you because the narrative begins, your client did something wrong. That's how the narrative begins. Your client is charged with something. Your client broke the law according to the piece of paper that is in front of the DA. So you need to be able to communicate the narrative as to why that happened, why there wasn't legitimate grounds for the stop to occur, why there was issues with what the officer was seeing. You need to be able to communicate that. So you have to be able to talk about the circumstances of the actual charge. What was going on the day of the offense that is important for the DA to get to the end result that you are hoping to achieve for your client? What happened during that time? And if the DA asks you a question, you want to be prepared to answer that. What kind of road was this on? Oh, it's on a little 2-lane highway. When did the officer first get involved? Oh, that happened after they had come to do a welfare check. You want to know the circumstances, because otherwise you're asking the DA to do their own digging, which is either going to be the officer's report, speaking directly with the officer, and now the officer is framing the narrative of what happened. DA may do this anyways. The DA may reach out to the officer anyways, but the narrative is going to be much more favorable if it's coming from the defense than if it's coming from the officer in the prosecutor's mind. In order to be able to give a narrative, you have to know the narrative. So know the case, communicate the case to the DA. Number 4, know your client's criminal or driving history. Almost every single time that you go to negotiate with the DA, maybe there's exceptions to this, but almost every single time there is going to be a question about what is this person's driving history? What is this person's criminal history? Don't waste the DA's time and your own time saying, I don't know. Right? If you go in to talk to the DA about a speeding ticket of 15 over and you're asking for a dismissal, the DA is probably going to want to know, what's his client's driving history look like, right? If they got a squeaky clean driving history for 10 years, that may actually be your best selling point. But you don't want to go in and ask for a 15 over. The DA says, what's this person's criminal history or driving history? You say, I don't know. And then they say, okay, well, let's run the driving history. And your client has 7 speeding tickets in the last 5 years. You should know that. That should be something that you have, that you're readily prepared to answer why we're looking for special circumstances, or to knowing if I'm asking for a dismissal, there is not a snowball's chance in hell that that's going to happen on this particular case. And so setting your expectations in a different spot. Same thing with criminal history. If you know your client's criminal history accurately, then that's going to go a long way in building trust with the DA about these negotiations. Very, very frequently, in anything that is more serious than a class 1 misdemeanor or a felony, anything that is at that level, the DA is going to want to know the person's criminal history. And you should know that, whether it's by asking your client, by getting a copy of the criminal history, looking in the file, whatever it might be. Before you begin your negotiation, you want to know, what is my client's criminal history? If it's bad, what happened in the past? If it's good, I want to make sure that I am bringing that out to the DA. My client is a first offender. They've never had so much as a speeding ticket on their record. You need to know that going in, and you need to have accurate information when you go into that conversation, because that's what allows you to build trust, not only in the particular negotiation that you're having with the DA that day, but in future negotiations with that same district attorney. If you're accurately communicating your client's criminal history over and over and over again, the DA is going to trust the other things that you are telling them about your client. This is something that can be verified, whether you know your client's criminal history or if you are misunderstanding or if you're miscommunicating your client's criminal history. This is a veracity check that the DA has the ability to look into. So if you don't know your client's criminal history, make sure that you say, I don't know, and at least be honest. But it's much better to actually know your client's criminal history, bad or good, and be able to communicate that as accurately as possible to the DA when asked or when it's important to communicate that. So number 4, know your client's criminal and or driving history. And finally, number 5, know your client's life. This is different than number 3 because number 3, we were talking about knowing the narrative of the particular event that led to criminal charges. Number 5, now we're talking about knowing who your client is as a person. When the DA looks at that citation or that F1 screen, your client is a number. They're a number. They're a file. You have to be able to make that number, that file, a person. You have to be able to communicate your client's personality, their humanity. If you can't do that, then your client is not going to get any type of special treatment. They can't because they're just a number. Why would you give special treatment to one file versus another file? You might give special treatment to one person versus another person based on who they are, what they've done, what they're involved in, but you're not going to give special treatment to one set of papers versus another set of papers. You have to be able to individualize and humanize your client every single time. And so again, this takes work. You have to ask your client, what are you involved in? What's going on in your life right now? If your client was speeding because they were late for their first day on the job, you need to know that. If your client was having a bad relationship with mom or dad, that was causing stress, started turning to alcohol, and that's what led to this intoxicated and disruptive charge, you need to know that so you can communicate that to the DA. Look, this is a one-time deal. This is what was going on in my client's life. This is not who my client is. He was dealing with a difficult family situation, a loss of his job, and that's why he was acting in this way. If your client's involved in organizations, teaches, regularly does community service, communicate that. My client contributes to society. He has paid a lot in. She has paid a lot in to society, to the community. And now she's made a mistake and she's asking for a break. And look at the body of work of good things that she has done. If your client is a student, a young person, if they're trying to become a professional, get a license, go into the military, you need to know these things so that you can communicate that to the DA. I have found that most DAs want to help people. They want to make the right outcome. There's a few DAs where it's all just black and white and you can't really have a meaningful conversation no matter what your client's humanity, personality looks like. They're just kind of in that 2 + 2 = 4. Therefore, we're not going to talk about what it is that you're asking me to do. But most DAs look at it and say, what is the right outcome for this particular case? And the more reason you can say to them, hey, let's do something that makes sense for my individual client and explain the reasons why you're asking for a specific disposition, a specific outcome, most DAs want to help. They want there to be a meaningful way to get to that point. And maybe it's that they're going to require community service, a mental health assessment, some other type of treatment, a period of not getting in trouble. Whatever those requirements look like, get those built around your client's individual circumstances. Look, neither of us want my client to be in the courtroom again, right? At the end of the day, the DA doesn't want my client to get charged with somebody down the road. I don't want my client having to deal with that either. Let's do something that is appropriate to the particular circumstances that will adequately discourage my client from committing the same act, engaging in the same type of behavior in the future. And when you do that, when you make it specific to your client, the DA is much more willing to buy into your argument and hear you out on what it is that you're asking for in terms of relief. You have to humanize your client. You have to make it personal. It's got to be personal. We always talk about business not being, it's business, it's not personal. When it comes to negotiations on a specific client's case, you have to make it personal so that it's not just a piece of paper in front of the DA, it's a human being. Hope that you guys can take some of these tips and apply them in your negotiations with the state, and I look forward to speaking with you again next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.